Hello, good afternoon to everybody, and a very warm welcome to my webinar on how to successfully mediate a family business dispute. It's really good to see from the attendance list that so many are old friends and also new people that I haven't met before. I'm very pleased to welcome people from France, Germany, the UK. Please send me on the chat where you're coming from. It would be super to hear where you are attending from. So for those of you who haven't met me before, my name's Rebecca Attree. I'm a mediator, solicitor. I mediate civil and commercial disputes, and I particularly specialise in mediating family business disputes. So disputes that have arisen amongst family members around a business very often may involve property, may involve intellectual property, may involve shares, may even involve inheritance. So just before I begin, welcome to everybody. I'd like just to ask to you, how many of you have been involved in a mediation in the past? I'm just going to do a short poll. So just to get a little audience participation here, you should be able to see the question, how many of you have been involved in a mediation in the past? So great, thank you very much for communicating and sending in your results. I will be announcing them very shortly. All the numbers are going up and down. I'm going to give you the percentages very shortly. Just a few moments left to vote. I think that's super, thank you. So pleased to announce that 79% of you have been involved in a mediation in the past, 21% haven't. So about three quarters of you. So I'm speaking to many people who already have some experience of mediation, which I'm really delighted to hear. Those of you who haven't been involved in mediation, I hope that what I'm going to say will give you a flavour. And those of you who have been involved, I hope that particularly this focus on family business disputes will give you some tips going forward, whether you're solicitors, barristers, or potential parties to a mediation. So what I'd say about mediation is that it refreshes the parts that other ADR methods can't reach, rather like the beer advert. It does things that arbitration, neutral evaluation can't do. My agenda in this short lunchtime slot, and by the way, I expect my main presentation will last about 35 to 40 minutes, and there'll be time for questions and answers at the end. So please feel free to get on the chat and send me any questions you may have, and I really look forward to hearing your input and sharing views at the end in a question and answer session. So the agenda is to look at the mediation mindset, look at the mediation landscape, what's happening in the UK with regard to mediation, how do you plan and prepare well for a mediation, and then some top tips, how can you get the most out of the mediation and how can you mediate successfully. So mediation basically means looking at a dispute through a new lens. It's all about looking for a deal on the day. You're trying to strike a transaction, totally different to litigation, where effectively you are at war. Here we're looking for peace. So it's all about coming advisors with that mindset, and indeed helping your clients, and if you are a party to a dispute, coming along and trying for the day of the mediation or the mediation session to put the past behind you insofar as you can, and to look forward and to look at what might be an outcome that would be suitable for you. Because conflict, after all, is all around us, and it's really how we deal with it that counts. And for many people, putting aside a dispute will enable them to spend more time on future opportunities, to have more money to invest in new opportunities, and to put away quite a lot of the stress of the past. And believe me, when families get into dispute, those issues can be particularly poignant. So at a mediation, a great deal of what is being done is hopefully good communication. And there are some barriers to communication. I've put up this picture here, some of you may have already seen it, of a lady. This comes from an excellent book that I would commend to you, The 7 Habits of Highly Effective People by Stephen Covey. If you haven't come across it, I'd have a read of it, because it's quite an important book on communication. But what Stephen Covey is saying in this picture is that this is one picture, but actually it can be seen 2 ways. Some of you may see an old lady looking down with her chin that's quite large, and her eyes are looking down. Others of you may see a young lady looking away with a feather in her cap, and just her eyelashes are showing, and she has a chin and a small ear. If you can't see both of those pictures, then send me a note on the chat and I can send you some bigger pictures and more descriptive pictures so that you can see it afterwards. But effectively, the reason I'm putting this up is to illustrate that here we have one picture. And if we had time, we could argue, is it an old or is it a young lady? It's one picture, but it's how people view it and it's their perspective. And that's what's going on at a mediation. There's been some kind of triggering event or events, and how they are seen by different people will have caused the dispute, because probably the facts of what happened are incontrovertible. It's how people have had their perceptions of it that's the issue. And the mediator is seeking to clarify those differences between the people. Is it an old lady? Is it a young lady? So let's move on to the mediation landscape. What is mediation? There we have a slightly foggy day with the Tower Bridge behind us. Those of you not in the UK, I hope you're enjoying just a moment of a snapshot of London and the city. So what is mediation? Well, a really key part is that it's confidential. What is said at the mediation is confidential, and the fact of mediation is confidential. So it's a moment to have discussions within a closed bubble and stepping away from perhaps the public arena of courts. The fact that it's confidential means that the outcome and the settlement is confidential unless a public press statement is agreed. And that means that we don't actually always hear about the success stories of mediation, but in fact, many large-scale disputes are settled by mediation. It's very flexible. You could set it up probably in the next 2 or 3 weeks. You will have a process that is flexible in terms of how many people will attend, how the meetings run. I'll tell you a little more about that in a moment. And it's pretty informal. There aren't any formal pleadings. I'll tell you a bit about how the meetings run in a moment. But hopefully people feel more relaxed than they would at court or at an arbitration. And that hopefully enables them to look at the situation with a calm approach, and to reach a solution in a rather more relaxed approach. I get a mixture of both parties who are represented with solicitors and possibly barristers as well, or sometimes there are people who come without representation. The thing I'd say about coming without representation is that the aim is to get a deal that's signed on the day, and if you don't have a lawyer with you, you may have difficulty in encapsulating the deal in a full-blown settlement agreement. That's going to be something you're going to need to rely on going forward that will be binding in contract. The discussions are also without prejudice. That means that they can't be raised in court. So what is said, what is disclosed can't be raised in court. There is one caveat to that, which I'll come on to later, which is if people are not reasonable at the mediation, it is possible after the main hearing at a costs hearing to have that evidence of unreasonableness adduced. So mediation, normally in my experience, it's a day, an 8-hour day. There's an opportunity to go on a little longer if people want to, but it is possible to mediate using the telephone. So you can set aside a morning and I will be telephoning between the parties and sometimes setting up joint phone calls. And indeed, just like you're joining here on Zoom, and welcome to this platform. This is actually the platform I use for online dispute resolution, so for ODR. So if I was mediating now with the many participants, and I'm pleased to see some more people are joining as I'm speaking, welcome to you, that actually it's possible that I could have each of you on a separate screen and I could see you and I could facilitate that you could all talk together or we talk separately. And ODR is a wonderful way to mediate, particularly with people in different countries, because it means you don't need to leave the comfort of your desk. You can mediate even from your phone if that's what you'd like to do, as long as you're comfortable with the technology. Mediation allows a whole range of settlement options. In a court, it's likely that a court may order monetary damages, so money award, whereas in a mediation, you can settle on whatever terms that you want to. The aim is to sign a settlement agreement at the end of the mediation session. Sometimes parties will just enter into heads of terms, so non-binding agreement. Perhaps that's in relation to a series of property transactions, because it isn't actually possible to do all the conveyancing at the end of the mediation, of course. But the point is that actually more people are satisfied with the outcome from a mediation than they are in court or arbitration, even if they win. The reason being that the outcome is something that they have chosen, and it's something that they have had an active part in reaching, rather than having it imposed upon them. So a few words about how is mediation moving forward in the UK. Generally, about 10,000 cases mediated in a year, so not a small number. It is on the increase, 5% increase in mediations since 2014. A high settlement rate, 86% settled on the day or soon after. I'd like just to focus for a moment on those words, or soon after, because we are seeing an increase in the number of mediations that settle in a few days after the mediation. Back in 2014, the figure was about, of those 86%, about 11% settled soon after. Last year, that 11% went up to 19% soon after. So what do we take from that? Don't give up if at the end of a mediation session, your 8 hours, the mediation hasn't actually settled. Leave offers on the table. Engage the mediator going forward for a few days or even a week or two, because it may well be that during the mediation you've narrowed the issues between you, and it just takes a little bit of time for the parties to reflect, possibly take more advice before they will actually fully sign up to the deal. I actually had a mediation recently where the offers were left on the table, both parties left their offers on the table, and 2 weeks later the deal was done on the terms of one of those offers. So it actually took a couple of weeks, but still significantly quicker than going to court, and it was the outcome that the parties wanted. So what happens if you're asked to mediate, or your clients are asked to mediate, and you're not sure about what to do? Some parties may think, actually, I'm unsure, maybe it's going to be a sign of weakness that I go to mediation. Well, something to bear in mind is that there are consequences of refusal to mediate. As many of you may know, if you go to court and win in England, generally you will get a large part of your costs back, and the other party will need to pay those costs. Now the courts are imposing cost sanctions on parties who refuse to mediate if that refusal is unreasonable. So basically the winner, even though they go to court and win, if later evidence is brought at the costs hearing that they weren't reasonable, they will recover less costs. And we've even had also a similar sanction imposed on a loser, where actually they had to pay the winner's costs on the higher indemnity basis. So they had to pay more of the other party's costs. So you may be wondering, well, when is a refusal to mediate unreasonable? Well, there is some guidance in the Jackson Handbook that tells us that actually there are some criteria for what may be an unreasonable refusal to mediate. What is unreasonable? Well, actually not replying to the other party within 2 weeks, according to a fairly recent case, could be an unreasonable refusal. So whatever happens, if you are invited to mediate, do get on and reply. Don't just leave it, because once 2 weeks has gone by, potentially that could be construed as an unreasonable refusal. When you do reply, give reasons as to why mediation isn't appropriate at this stage. Actually, to say we don't think there's any prospect of settlement has been held to be not a good reason, and that is not a reason to refuse. The courts have said there is always a prospect of settlement. Sensible reasons that may mean that it's a reasonable refusal is to say it's too early. But if you're going to say that, say we would be willing to mediate later, so that you haven't closed the door on mediation for the future. So selecting a mediator, how would you go about selecting a mediator? I was talking to somebody only yesterday who was mediating in Northern Ireland, and they said it took us such a long time to agree when and with who we should be mediating. A fairly neutral way of going about it is to go through a panel. I've recently set up a panel, Hexagon Mediation, with 5 other like-minded mediators. And if you come to us at Hexagon Mediation, it's possible that we will then propose 3 mediators, and it's a one-stop shop. So you can then put forward those 3 mediators to the other side, who can then choose from those 3 mediators, and the mediation will be then set up. So the benefit is you have already the availability of the mediators, the suitability. Otherwise, it's possible that you go by direct appointment. So for example, you could come to me directly through my website and then suggest the mediator to the other party. I am often told by solicitors that actually their approach is that if the other party recommends a mediator or suggests a mediator, that they will go with that suggestion unless there is a good reason not to, because really why create further discord and further dispute in order just to get to the mediation. The things to think about when you're looking for a mediator is how experienced is this mediator, and particularly are they experienced for this type of case? Now, I wouldn't be too narrow in that view, because generally a mediator is going to be using a whole range of communication skills, and the fact that they are a good mediator would mean that they should be able to mediate a very wide range of case. But still, having some industry knowledge may be something that you're looking for. There's quite a lot of debate about should you have a lawyer or a non-lawyer. A good mediator will look beyond the law and will look to the other commercial issues and the personal issues, but having a non-lawyer means that perhaps they won't be as fully familiar with some of the legal arguments, although the mediation is not the place to be rehearsing the legal arguments in detail. A lawyer will at least have a lot of familiarity with the litigation process, but many non-lawyer mediators have gained that knowledge through their experience as a mediator. You may want to think about having 2 mediators. Many mediators engage in co-mediation. Sometimes I co-mediate with others. It may be that it's useful to have 2 people with slightly different skill sets. It may be that there are language issues. It may be there are cultural issues, or even faith issues, religious beliefs, and parties can want to have possibly 2 mediators so that there is a greater breadth of knowledge and understanding. Probably I would say an important issue is what's the mediator's focus? Are they very much on the law, or will they look more at the commercial issues and bring empathy as well? And of course, finally, what's the availability? You don't want a mediator who's so booked up that they have been mediating for the last 9 business days before they come to your mediation. You want a mediator who hopefully is not mediating the day before or the day after your mediation, so that they can prepare well. And also if there's some follow-up the following day, then they're available to do that. Good, I'm seeing some questions coming in on the chat. Thank you very much indeed for doing that. Do feel free to raise any other questions that you would like to raise, and indeed I will be also conducting a poll shortly going forward, a further poll. So, planning a mediation, what should we be doing when we're looking ahead to plan the mediation? Well, one of the things people often consider is who's going to attend. I think the more people around the table, the harder it is to get a very focused discussion. And therefore, I would err on the side of having fewer people from your organisation or fewer advisors present. But equally, you do want to have your team on the day so that you do have everybody with their input. Sometimes with family business mediations, people will say, well, the more people that attend from one party, that gives an indication that perhaps there's more money to be paid. In my experience, it's not always the case. I've had situations where the number of people who've come from one family, actually they have been brothers and sisters, and there's been the parents there, and the brothers and sisters have been there largely to protect their future inheritance, because if the parents are going to contribute to any settlement, the brothers and sisters of the party are saying, well, actually, we want to make sure that there will still be enough for us to inherit later if the parents are making some kind of upfront payment on behalf of one sibling now. Barristers can be very helpful as well as solicitors. It rather depends on the budget. It also depends on whether the other party is going to have any legal representation at all. But certainly barristers can be particularly useful when it comes to drafting a settlement agreement if it's quite a technical area, because that is very much their skill on that drafting, especially if the settlement agreement is going to become part of a Tomlin order and given the enforcement through the courts. Very key is that the parties have authority to settle. Nothing worse than parties coming and then later saying, actually, I need to make a phone call, and the person to whom they need to make the phone call to get the authority has gone home. Equally, if there are insurers involved, make sure that there is an opportunity to check what is the level of settlement that the insurers would be agreeable to. And indeed, often it is good to have the insurers actually present. Thank you. I've just had a comment here from someone asking about a Tomlin order. I've just noticed that one, just to deal with that very quickly. Essentially, if there's litigation already going on, then the courts may well have stayed the proceedings whilst the parties are given an opportunity to settle the dispute. If then at the mediation a settlement agreement is reached, then what will often happen is that settlement agreement will be confidential, but it will become a schedule to an order that is drafted, which basically says to the court that the parties have settled on the terms of the attached schedule. And then that is then put before the court for the judge to approve, and it's sealed. And then that Tomlin order actually has the force of a judgment and can be enforced against others. Excellent. So just carrying on with the points here, the venue, where are you going to mediate? I find it surprising how many people do have quite a discussion about that. I think the venue does make a difference to people's feeling and comfort on the day. Generally, having 3 rooms is a good idea if you've got 2 parties, but 2 rooms is maybe well be sufficient, and I as the mediator will generally be in one room or the other. I think getting a venue that has privacy is important. Sometimes I've found people have tried to save costs by going even to a library and taking a room there or 2. Generally, this is less desirable. Some hotels can be suitable, but it's worth just checking how far away are the rooms going to be, because if they are on different floors at the end of very long corridors, that can make for a more cumbersome set of communication. In terms of defining the dispute, that's something that people often think is very simple, and it may be if there are already court proceedings pending, because you can refer to the claim number. But because of the issue of costs and protecting yourself on costs or your client on costs, it's very important that when you enter into an agreement to mediate, which is the agreement that basically is between yourselves and the mediator about the mediation session, that you define the dispute potentially as widely as you can, so that you will cover all related issues, and you will then get the cost protection for the scale of that dispute and the wider issues. Also important to think beforehand about tax. In my experience with family business disputes, quite often there's quite a lot of tax involved. It may be capital gains tax, it may be inheritance tax. Think beforehand of possible settlement orders or settlement agreements that you may have, and what might be the tax implication, because there have been some cases, such as the case of Barden, where subsequently parties sought to undo a settlement agreement saying, well, we made that deal, but actually we didn't realise what the tax issues were. And that is generally frowned upon by the courts. So moving on to the negotiation strategy, a part of working out the negotiation strategy is, how will we begin? Are we going to have a joint open meeting? Generally, joint open meetings are desirable because it gets everybody around the table. It means the mediator can welcome everybody and say the same thing to everyone about the process. But quite often, and actually in my experience increasingly so, particularly with family business mediations, people are reluctant or are saying, actually, I don't want to do this. I would never insist, and I would always respect someone's view on this. I've had many mediations that have settled, even though there hasn't been a joint open meeting, and indeed the parties haven't seen each other during the course of the mediation. I think if one party is going to come and be very emotional and speak in quite emotional terms, it's probably better not to have a joint open meeting, because that can set the tone for the mediation, which is different to that mindset I was describing earlier of wanting to have an approach of peace, and it can actually set off another battle. If the parties are comfortable with just attending the meeting and saying nothing and their advisors speaking, that can be very desirable. If the party just wants to say, I'm here with a view to settle, that can be a very positive thing, just to see the person and to hear them saying that. The other thing I'd say is, just because there isn't a joint open meeting, I'd never say never. It may be that later it's a good idea to have a meeting, and it may be actually that sometimes just having the two key decision makers together could be a way forward. I had a mediation where actually it was older generation and younger generation in two sides of the family. And in the end, we concluded by having the two younger people together and going back into their separate rooms to talk to the parents, and coming back and then negotiating the deal with me there as well. And in that situation, they were doing the negotiation, but the parents and actually their advisors remained in their separate rooms. One of the things that often people overlook when going to a mediation is the other party. A lot about mediation is about getting into the mindset of the other parties. Where are they coming from? What kind of counter offers might they make? What could they be looking for? Are there any non-financial things that we could offer to them that perhaps wouldn't cost us very much, but might be suitable for them to have? And what kind of settlement ranges are there? What various outcomes would be suitable? So thinking about a range and not just getting fixed on one idea, I think, is a good approach. When it comes to closing a deal, and this is what, of course, you're going to be looking for at the mediation, research has shown that there are three component parts. You need to satisfy the logical needs of the counterpart. Usually the lawyers are extremely good at looking at the logical and the analytical approach to the case in hand. But actually, there are two more things on top of that that are needed. It's necessary to satisfy the emotional needs of the other party. What does that mean? That they actually want to make a deal. It may be that an apology is necessary to get them into that mindset. And also convincing the other party that you're at your bottom line. So could we have got more? Quite often people will say at the end of a mediation, do you think I could have done better? How do you convince the other party that you're at your bottom line? by being reasonably honest and frank at the beginning in the exploring sessions about where you're coming from with the mediator, and if it's appropriate, allowing that disclosure to go back to the other party. The other way that you can really successfully convince someone is by looking at them straight in the eye and saying, this is as good as I can offer you right now. So actually getting the key decision makers to talk to each other, if they're comfortable, if their advisors are comfortable, even if it's just a very short conversation saying, look, you know, I really think we should settle at this point, can be what is necessary to convince the other party that this is a moment when it's a good point to settle. And I would also always say, is this good enough for you? Going to a mediation expecting you're going to get the best deal is unrealistic. Ask yourself, is this good enough? If it is good enough, having looked at your risk assessments, which I'll come on to, then probably that's a good reason to settle. So preparing realistic settlement options is another part of preparing, evaluating the legal and factual position, liability, and also quantum. How strong is our case? But then beyond that, and I think this is where we step outside of the legal situation, but we move on to what are the commercial interests? How will reputation stand up if this case goes to court and it goes all over the press? Is the person who may have to give a lot of witness evidence personally strong enough to withstand that, and particularly being cross-examined? Are there regulatory issues perhaps in the background that could be resolved through the mediation and then new processes taken on? And then part of the risk assessment, which is often a part that really focuses people's minds, are what legal costs have been incurred so far, and what are the costs likely to be to date? Because in my experience, very often the legal costs so far and going forward of both parties may well be more than the amount at stake. And so parties may say, actually, we would rather have an outcome where we can pay each other something and reach a solution. Oh, by the way, quantum is the amount. So it's liability is, are we liable? Quantum is what is the scale that a court might order us, what might be the award that we would have to pay as a monetary figure. And then projecting, how would this look in the other room? If the other room were to make this assessment, what do we actually think the other party's strength of the case is, and what are their commercial interests? Do we have somebody who's about to retire? Quite often family business disputes involve intergenerational issues, and it comes about because one party actually wants to retire, and it may be that they don't want to wait a whole year to go to court, and there's quite a compelling argument for a settlement to happen now so that they can move on and have their retirement. Other things to prepare: what might the other party say or do? What might they be their response? Remember that the person that you're seeking to persuade is the person in the other room. The mediator may ask questions that are quite probing or challenging. It doesn't necessarily mean to say, if that's me asking those questions, that I don't agree with what you're saying or I don't think your view is correct. More what I'm doing is probing to see whether you really believe what it is that you're saying, and also to indicate that perhaps someone else, even such as a judge, may have a different view. And really, the mediation is about stepping back from the legal and the factual detail. Frankly, the smaller the bundle that is sent to the mediator beforehand and to the other party, the better. Very often, the bundle might get opened in the first couple of hours, but after that, if a mediation is going well, actually, we're moving on to creating a deal. And the bundle is there for information and for reference, but you're wanting people to really focus on what would be a commercial deal, and some lateral thoughts on that can actually be really, really useful. So what kind of lateral thoughts might parties have, and what kind of outcomes may there be? Well, as broad as your imagination. As I've mentioned, the courts are more likely to order money payment, but other possibilities could be that the ownership of the business changes, that the shares are transferred between the parties. Something there to bear in mind is if you're offering to sell your shares for a certain price, it's quite possible that the other party may say, actually, why don't you buy my shares for the same amount? So it's a bit of a put and take option type approach. And then your view on what would be the correct price may change, because usually people have a different price for if they're buying or selling. So think about that really quite carefully. These other issues, resignation of officers or an apology, allow a greater range of outcomes, and these of course would not be ordered in a civil court, and therefore these give a greater opportunity for outcomes that people will feel possibly more comfortable with. Other outcomes could be a management buyout. Let's plan for the future. Let's say, okay, we will work for the next 2 years towards the next generation buying out the older generation. Clearly the settlement agreement couldn't have all the terms of the management buyout. That would be a situation where you may well have heads of terms at that point. Granting share options for the future could be a way forward. Reallocating who is going to do which role. It may be that the dispute has arisen because certain people had adopted certain roles or positions in the organisation that actually in the longer term they're not so suited for. Giving people performance targets, saying, okay, it didn't work before, I'll give you an opportunity to prove yourself that now you can do better. Having agreed methods of working, we'll have board meetings once a month, we'll have weekly phone meetings, agreeing how to improve communication. And on the back of that, there may even be some admissions in the mediation, privately probably, that certain people are lacking in certain skills and needing to upskill, and therefore there may be some agreements for investment in training or coaching of certain key people going forward. So it's about looking also at why is this dispute arisen and how can we make things better for the future. Even issues such as who's going to be the boss in 2 years' time. And this can be an opportunity to really look at planning for the future. And indeed, succession planning may often form a part of a successful family business mediation. As I've mentioned, it may be that a person is wanting to retire, and therefore planning who will be the future boss, and then actually going away and writing a will that will reflect how the shares will be transferred following the agreement in the mediation itself, because sometimes there's quite a vagueness in families. Sometimes somebody may say, you know, one day all this will be yours to their son or daughter, not realizing that if actually the will that they write says something quite conflicting, there may be issues of promissory estoppel, and there may be Inheritance Act claims that are brought later on. So getting clarity, if people are actually willing to do that, as a result of the mediation, can actually help on a number of fronts. And one of the key advantages to transferring an inheritance through a business is that the transfer of shares through an estate of a deceased person is actually inheritance tax exempt. And so this is a way that sometimes people will plan for the future. The other issue for family businesses is, how is this business going to fly? Who's going to invest money going forwards? And people are often very keen to invest at the start, but then after that initial flurry has happened, it can be harder to get people to agree to invest. And so formalizing when will capital injections be made into this hopefully now flourishing business could be a part of a mediation and settlement agreement. So what are we going to give to the mediator, and what are the obstacles to settlement? What are the difficulties out there? Well, personalities. In my experience in family business disputes, personalities often loom large. And of course, everybody knows each other, particularly if it's a father and son, mother and daughter, however it may be. And I hear often expressions such as, well, you know, he always spent his pocket money the second he got it. So really, he's going to spend all the money anyway. He's not going to run the business well. And so people have a lot of history that they're bringing to a mediation. And as a mediator, it's important to encourage the parties to step away from some of those psychological biases that they've perhaps carried for years, and to try to look at the other person as a business person and as a person that they are in commerce with. The benefit of a mediation is that it can deal with these personality issues rather better, because if there isn't a joint open session, there is nothing that is said from one party to the other, and unless it's been approved and it's delivered by the mediator. And I often say, you know, one of the difficulties of having a joint open session, if people are emotional, is that you can't unsay what has been said. Whereas if you say something to the mediator, it's possible that they will hear and listen and rephrase it, and if authorised, deliver the message in a rather different manner to how that big personality in the other room might have done so. Other obstacles to settle: it may be that the timing is wrong, it's too soon. I usually think it is a good idea to try and mediate before a party begins a formal claim, but it may be that getting the attention of the defendant is hard, because they may think, well, I don't know if they're actually going to sue me. Psychological biases I've mentioned already. One, I think, of the key things is that if you're in a dispute with somebody, you probably don't trust them very well at all. And therefore, if you don't trust the person, you're unlikely to trust what they say. That bias can be overcome by the mediator being the conduit of communication. But there are many other psychological biases. We tend to hear what we want to hear, see what we want to see. And so it may actually be that there are things that people are missing or overlooking. Back on that picture of Stephen Covey's lady, and was she old or young? We can be biased in what we see. Other obstacles can be, frankly, too much detail. People are wanting to have technical, factual investigations. They want an evaluation of the price of the shares. I've had a number of mediations where there has been an expert's report on what would be the correct value of the shares. That is helpful, but focusing too much on the facts and the detail of a report can take people away from looking at the bigger picture. And the point is, you're never going to know for sure. A mediation is about making a view on the basis of the facts and the advice that you have at that moment. And you could always say, well, we could go and get more experts' report, we could get more evidence. The point is, are you willing to come to a deal? Other obstacles is what's going to be said to others. Usually in a family business mediation settlement agreement, there is a caveat that the confidentiality will be released as between very close family members, so that others can go away and tell other family members that the matter's been resolved. But usually people just want that to be said and nothing more. So just, we've settled our differences at mediation, and it's actually agreed that that is the statement that people can make. So these other obstacles could be HR, could be finance, I've mentioned tax as well. Important that the input is gained beforehand in terms of what you need to know before you get to the mediation. So moving on quickly then to just a last few points before I close. I see there's a few questions coming in. I'd like to have time to deal with those as well. Mentioned already, keep it short and simple, what you send to the mediator. The bundle, ideally one lever arch file. The mediator is going to want to know what are the history of the negotiations and offers. Is there a Part 36 offer that's been made into court? What are the costs? Who's coming? What's their status? Are they a party? Are they attending as a supporter? And also very useful to know family relationships of those attendees. Whether people in principle are willing to have a joint open meeting, any time constraints, and then probably more likely on the phone with the chat with the mediator before the mediation. I always ring people up the week before and say, is there anything else you'd like to tell me? And so is there any information about any of the attendees? Here, just very briefly, overlap of what is the classic situation at the beginning of a mediation or a negotiation. You've got the party with their position, what they're saying they want, their interests, and then their needs, each party with each of those. And what we're looking for in a mediation is to find an overlap of needs and probably to some very small extent an overlap of interest. The best mediations will have an even bigger overlap of interest than I have shown there. So just very briefly, a word on lawyers. I'm very pleased to welcome quite a number of solicitors and barristers to this webinar. How good are lawyers at predicting outcomes? Well, there's been some research by Randall Kaiser in the US who looked at cases and outcomes and whether people were willing to settle or not. And he found that actually only 15% of cases, the parties and their advisors had made no error in refusing a settlement. So he compared offers of settlement with what parties then went on and received as an award. Of those 85% who made errors, and these were the lawyers making errors, more errors were made by claimants. 61%, a large number, compared with 24% of defendants. But the cost of making that error was much, much greater for the defendants. Extra cost, 150% to 225%. So really very significant. So what should we deduce from this? It's all about the loss aversion or the endowment effect, that people often demand more to give up an object than they would to acquire it. People value something more highly when they possess it, just like I said about selling shares. If I'm selling it, the price in my mind is likely to be higher than if I'm asked to buy them. So defendants can be harder to persuade because the greater the loss, the less likely they're going to agree to it. And defendants typically are less likely to make an offer before a trial if there hasn't been a mediation. And they may well evaluate offers less rationally. A whole lot of psychology behind that. So just to wrap up, and I'd like to do a poll before I do. My last poll before I just give you my top tips. I'm going to move to my poll. Oh, sorry. Oh, sorry, bear with me. Maybe I didn't share the results of the first one, so I'm moving on to my poll. You're viewing the results. So moving on to my second poll. Aha, excellent, good. So now we have poll 2. Would you poll 2? Would you now consider mediation before starting legal proceedings? So just to invite you to give your answer to that, please, before we close with some top tips and quick Q&A. Thank you. Excellent, thank you. I can see that you're voting. Oh, you're all very, very quick. Thank you very much indeed. At the moment, it's 100% yes. So thank you. Excellent, just a few more moments if anybody else would like to vote, please. Just while that poll is concluding, I'll just give you my top tips. What should you do to successfully mediate a family business dispute? Be open with the mediator. Tell them what it is that you are wanting and where you're coming from. Listen carefully to what the other parties say if you're given messages through the mediator. Listen carefully to the mediator. Put yourself in the other party's shoes. Make sure you think about where are they coming from? What can you give to them that perhaps won't cost you too much? How will their risk assessment be looking? Definitely beware information overload. Don't come with a whole lot of new facts and figures. and keep a track of the pattern of negotiation, because that will give you an indication of where it is going to. So I'm pleased to say that the poll has now closed, and we have 100%. We have everybody on the on this webinar agreeing and saying yes to the fact that they would indeed consider mediation before starting legal proceedings. So thank you very much indeed for that poll. And also just to remind you that when we began, of those of you present, about 80% of you had already used mediation. So I'm very conscious that I'm speaking to a number of you who are very already experienced in this field, and those of you also who would like to be using it. So just in this time left, thank you very much indeed for your questions and answers, your Q&A. So just reading a few of these out. Some mediators say that what they often do is get the parties to settle on something they're not happy with, but they can live with it. Is this your experience as well? Thank you. Interesting question. I would never advise a client, well, I would never, as a mediator, I don't advise. What I was trying to say is I would not support a party to settle on something they're not happy with if truly they are not happy with it, because they are probably not going to be satisfied with that outcome. If they say that they can live with it, I would explore much more and see what does it actually mean to them? How would it look? How would life be with that settlement outcome? And I would encourage them to compare that outcome with what might be the outcome if they don't settle at the mediation. So ultimately probably going to court or arbitration. And it may be that the outcome at court or arbitration is something that they could live with even less, and they would be less happy with, in which case I think then if they do want to settle, then that is a matter for them, and they have then made their risk assessment and realised that they may not be happy with the outcome, they can live with it, but they're likely to be happier with it and can live with it more easily than going to court. Thank you. And then another question, do you feel that you lose some of the effect that you get with the personal touch in ODR? Yes, I think you do lose a small amount. The communication statistics are that body language is a large part of communication, about more than half. So you do get the body language on an ODR platform, but it's not going to be the same as actually sitting in the room with somebody. So I would say it's probably about 90 to 95% effective, but its effectiveness does also depend on how comfortable people are with using it. In my experience, the younger generation, the younger people are going to be more comfortable with ODR than perhaps people of more senior years. And another question I have here, very nice question and a comment. Distinctions between mediators who are not lawyers and those who are lawyers is, in this person's view, unhelpful. He's saying, from my experience as a mediator who's also a lawyer, most non-lawyer mediators get mediation far better than the mediators who are lawyers and who treat mediation more as a settlement process than a conflict or problem-solving one. I think you are making a very good point when you say that. I think there is a distinction between mediators who are lawyers and who aren't, but I think there can be a tendency for some lawyers who are mediators to get just too involved in the legal details. And indeed, I train mediators, I train people to become mediators, and it can be that those non-lawyers actually come from a more open approach. But having said that, I think that having somebody who understands the litigation process and who understands some of the legal arguments just means that there's quite a lot of background that they will bring to the day that potentially a non-lawyer would not. But I quite understand and appreciate your comment that mediation is all about conflict and problem solving. How are we doing for time? I think we've got time for one last question, which I'm just finding here. Thank you very much. Can you tell us a bit more about there being mediators with different focuses, commercial, empathy, or legal? Do you as a mediator empathise with the parties or feel that's a slight compromise on neutrality? Excellent. Well, I think the different focuses, commercial is very much looking at the deal. And I think in family business mediations, often that's what people want to do. There may be clear commercial reasons why a particular outcome is going to be suitable for all the parties. Empathy, it may well be that there have been different power biases within the family. It may be to redress parent to child differences. It may be that people have never really listened to each other properly. The legal, I think I've spoken about just now with the lawyer and non-lawyer. I think a good mediation will not focus on the legal points too much, and will look at the legal points in addition to commercial and the empathy points. And in terms of as a mediator empathising with the parties, I think an element of empathy is very important, because what you're wanting to do is to build trust and rapport with the parties so they can tell you really honestly where they're coming from and what they want to achieve. And I don't think it's a compromise on neutrality, because what you're not doing is sympathising. You're giving empathy, which is saying many people in your situation might feel like that, or I understand where you're coming from. It isn't saying to the person, you're right. It's actually saying, I understand why you are feeling as you do. And for many people, having that understanding can help them then to be more honest and open, and then explain what it is that they are wanting to do.